Thank you, Carla. That was a lovely introduction. I'm delighted to be here. I'm a big fan of the Chicago Humanities Festival and of Carla Scherer. So what I want to talk to you about this morning derives from this book, Sex and the Constitution, that was published last month. And just to give a bit of background, this book was an unusual enterprise in the sense that when academics write books, it's normally at the end of a long process in which they have researched, written articles, presented presentations at workshops, debated with students and faculty, taught about the subject, and the actual writing of the book tends to be only after they have basically mastered what it is they're going to be saying in the work. In this case, Sex and the Constitution was very much a curiosity-driven process. About 10 years ago, when I started thinking about this, I was curious about the fact that over the last then half century, now 60 years, the Supreme Court had begun for the first time in its history to get involved in interpreting and applying the Constitution to matters that were related to sex, matters like sexual expression, contraception, abortion, sodomy, same-sex marriage, and so on. And I wondered, what would the framers of the Constitution have thought about this? Would this have completely shocked them that what they had produced at the end of the 18th century was now being interpreted in a way to guarantee these so-called rights? Now, I'm not an originalist, but it was a matter of curiosity to get a sense of how they would have reacted to this. And my basic assumption when I began thinking about this was that the general set of attitudes in our society in the 1950s about sex, which were fairly prudish, were more or less the norm historically, and that it was the sexual revolution of the 1960s that completely transformed social attitudes, created conflicts in society that hadn't existed before, and that ultimately culminated in a series of Supreme Court decisions. And what I discovered when I went back and started looking at the world of the framers was that that was completely wrong, that it was far more complicated than I had ever imagined. And that got me curious to go back further in history. And ultimately, I found myself going all the way back to the Greeks and the Romans and the ancient Hebrews and to the beginning of Christianity to try to understand where our attitudes about sex came from, how they evolved over time, how we got to the point of the world of the framers. And then moving forward from there, I became curious about how we went from the world of the framers to the world of, say, the 1950s, which was not a straight line along the lines I would have imagined. So Sex and the Constitution as a book is basically the exploration of that history and what for me was a very surprising and exciting inquiry into these developments. So to introduce Sex and the Constitution to you this morning and to give you just a glimpse of the nature and scope of the work, I want to tell you a story. It is a story about what for 4 decades now has been one of the most bitterly divisive issues in American politics, the Supreme Court's 1973 decision in Roe versus Wade. Now, opponents of Roe maintain that the court in that decision invented a constitutional right out of whole cloth without any legitimate justification. Supporters of Roe maintain that it was a perfectly sound decision that correctly recognized a fundamental constitutional right of women. Whether one agrees or disagrees with Roe, contemporary understandings of the decision and of its historical origins turn out to be often confused and incomplete. The story of how we got to Roe v. Wade, like the story of how we got to Brown versus Board of Education, or how we got to Obergefell versus Hodges, the Supreme Court same-sex marriage decision 2 years ago, is important to remember, for it gives both content and context to the debates of the present. So let us begin at the beginning. At the time our Constitution was drafted, abortion was often relied upon by single and widowed women in particular to avoid the consequences of unwanted births. In that era, contrary to what many people, most people I suspect, today assume, abortion before quickening, that is, before the point at which the woman can feel movement, usually at around 4.5 months, was perfectly legal. Indeed, this had been the unbroken state of the law, at least as far back as the ancient Greeks. Although the Church in the Middle Ages condemned abortion as a sin, the law did not treat abortion as a crime. To the contrary, those who did not share the faith were free to do as they wished. Abortion was also common and legal in England in the years leading up to the American Revolution. As Lady Caroline Fox wrote to her husband in the 1740s, upon learning that she was pregnant for the third time in as many years, quote, "I'm certainly breeding. I took a great deal of physic yesterday and hoped to send it away." Soon thereafter, she wrote her husband that she'd been successful, noting, "Is not that clever?" At this time, a wide variety of female pills were readily available in London shops for the purpose of inducing abortion. The American colonies embraced the same approach to abortion as the English common law, and abortion before quickening was both common and legal. Moreover, even abortion after quickening was almost never punished. Now, over the course of the 19th century, abortion became ever more common in the United States. This was evident in the fact that the birth rate in the United States fell dramatically from 1800 to 1900. In the colonial era, the average family had 9 children. By 1900, that number was only 3. The reason for the change was clear. In the agrarian world of the 18th century, children were an important economic asset. But by the end of the 19th century, with greater urbanization and industrialization, children were increasingly seen as a financial burden that could cause a family's economic ruin. Thus, for most families, birth control had become essential. And because contraception was generally unreliable, abortion was seen as a critical way of managing family size. Indeed, by the middle of the 19th century, approximately 20% of all pregnancies ended in abortion. At this time, abortifacients were readily available from mail-order firms and from pharmacists. Daily newspapers regularly ran ads for abortifacients, and those who provided abortion services did so quite openly. The flamboyant Anne Lohman Restel of New York, for example, who was popularly known as Madame Restel, maintained a highly profitable abortion business, serving a genteel middle and upper-class clientele in New York. She touted her celebrated powers for married ladies, and like many of her competitors, she broadly advertised her services in the penny press of the day. To give you just a sense of the times, here's an example of one of her widely distributed advertisements in the 1850s. Quote, "To married women, is it but too well known that the families of the married often increase beyond what the happiness of those who give them birth would dictate? In how many instances does the hard-working father, and more especially the mother, of a poor family remain slaves throughout their lives, urging at the oar of incessant labor, toiling to live, living but to toil? Is it desirable then for parents to increase their families regardless of consequences to themselves or to the well-being of their offspring, when a simple, easy, healthy, and certain remedy is readily within our control?" The general acceptance of abortion as an appropriate method of managing family size began to change for the first time in the latter part of the 19th century. 2 factors in particular contributed to this shift. First, religious perspectives on abortion began to change during the evangelical explosion of the Second Great Awakening. The traditional Protestant conception of the fetus assumed that it was not alive until the point of quickening. Abandoning that view, evangelicals during the Second Great Awakening began to preach for the first time that a separate, distinct, and precious life came into being at the very moment of conception. Second, medical professionals in this era increasingly came to the view, based partly on religion and partly on often half-baked science, that human life begins at conception. A professor at the University of Pennsylvania Medical School, for example, published a pamphlet in which he confidently asserted that newly conceived embryos can think and can perceive right from wrong. And in the late 1850s, the Boston doctor and religious moralist Horatio Storer initiated a concerted physicians' crusade against abortion. Part of this, by the way, was driven by the effort of doctors to drive midwives out of the control of gynecological treatment of women. And part of it was due to a view of women. The view of women at this time regarded women as temptresses. They were Eve-like creatures who could not control their sexual urges. And as a result of that, they would corrupt and tempt men. And they would engage in extramarital affairs and would therefore do damage to their husbands and their families, and it was necessary to control these urges. One of the ways to control those urges was to make them pay the price of unwanted children if they were to violate the expectations upon them. So Storer decried the growing frequency of abortion in America and maintained that the primary cause of this phenomenon was the general immorality and demoralization of women. Storer insisted that some women who have an abortion die, either immediately or shortly thereafter, as a result of, quote, moral shock from the very thought of what they have done, while many others were driven to insanity. Storer charged that children born to a woman after she's had an abortion are often deformed or diseased, and that they too therefore bear the burden of their mother's heinous act. Storer emphatically rejected the notion that a woman should decide this question for herself, because, he explained, during pregnancy, a woman's mind is prone to derangement. As a result of Storer's campaign, in 1859, the newly founded American Medical Association adopted a resolution condemning abortion at every stage of gestation, except when necessary in the eyes of a doctor to save the life of the woman. Over the next several decades, the AMA, working hand in hand with religious moralists during the late 19th century social purity movement, launched an aggressive and ultimately successful campaign to rid the nation not only of abortion, but of contraception as well. As the leading voices of this movement explained, the sole purpose of woman is to produce children, and women must therefore remain within their God-given sphere. By the end of the 19th century, in a complete reversal of the world of the framers, and indeed of all of Western history, every state in the United States had enacted legislation prohibiting the distribution of any product designed for purposes of contraception and the distribution of any information about contraception, and every state had enacted legislation prohibiting abortion at any stage of pregnancy unless a doctor certified that the abortion was necessary to save the life of the woman. Thus, for the first time in Western history, abortion was unlawful even before quickening, and women who sought abortions were now themselves subject to prosecution. Opponents of birth control insisted that the issue was simple. If a woman didn't want to get pregnant, then she shouldn't do anything that might get her pregnant. It was as simple as that. Now, despite the threat of criminal sanctions, the medical profession's often perverse warnings about the dangers of abortion, and the preaching of religious moralists, women in the late 19th century continued to seek abortions in record numbers. Indeed, by the turn of the 20th century, approximately 2 million women each year had an illegal abortion, and almost a third of all pregnancies ended in abortion. But now, for the first time in history, these abortions had to be performed illegally, in secret and unsafe circumstances, and by much less reliable practitioners than in the past. By the 1960s, with improvements in contraception, which was now increasingly but still not universally legal, the number of unwanted pregnancies gradually declined. But even then, approximately 1 million women each year resorted to illegal abortions. The vast majority of these women continued to turn either to self-induced abortion or to the dark and often forbidding world of back alley abortions. Women who resorted to self-induced abortion typically relied on such methods as throwing themselves down a flight of stairs or ingesting or inserting into themselves a chilling variety of chemicals and toxins. Knitting needles, crochet hooks, scissors, and coat hangers were among the tools most commonly used by women who attempted to self-abort. Approximately 30% of all illegal abortions at this time were self-induced. Women who sought abortions from back alley abortionists encountered similar horrors. To find someone to perform an illegal abortion, women often had to rely on tips from elevator operators, taxicab drivers, salesmen, and the like. Because of the clandestine nature of illegal abortions, the very process of finding an abortionist was dangerous and terrifying. Women who sought back alley abortions were often blindfolded, driven to remote areas, and passed off to people they did not know and could not even see during the entire process. Such abortions were performed not only in secret offices and hotel rooms, but also in dank bathrooms, in the back seats of cars, and literally in back alleys. The vast majority of these abortions were performed either by persons with limited medical training or by rank amateurs, including elevator operators, prostitutes, barbers, and unskilled laborers. In the 1960s, an average of more than 200 women died each year as a result of botched illegal abortions. And in addition to those who died in the course of illegal abortions, many thousands more suffered serious illness or injury. Moreover, this was a world of secrecy. Because abortion was illegal and because it had become shameful in society, women who undertook these experiences kept them secret from everyone except perhaps a few close friends. They lived in a world of shame and embarrassment and mortification. The stories of women who suffered through this nightmare are truly horrendous. One woman recalled how a fellow college student who had had an illegal abortion was too frightened to tell anyone what she had done. She locked herself in the bathroom in her dorm and quietly bled to death. In another incident, 28-year-old Geraldine Santoro bled to death on the floor of a Connecticut hotel room after she and her former lover attempted an abortion on their own. The former lover, who had no medical experience, used a textbook and some borrowed tools. When things went terribly wrong, he fled the scene and Santoro died alone. The occasional visibility of such incidents, usually when they resulted in tragedy, led some religious organizations that had previously been silent on the issue of abortion to address the question more directly. Protestant churches varied in their opinions. The United Methodist Church, for example, acknowledged the sanctity of unborn human life, but nonetheless proclaimed, quote, "Because we are equally bound to respect the sacredness of the life and well-being of the woman, for whom devastating damage may result from an unacceptable pregnancy, we support the removal of abortion from the criminal code." Similarly, in 1968, the American Baptist Convention came to the conclusion that abortion should be a matter of responsible personal decision. The Catholic Church, on the other hand, insisted that abortion was always and unequivocally forbidden, even when necessary to save the life of the woman. Now, this led politics of abortion to play out in interesting and unexpected ways. Because Catholics had traditionally identified with the Democratic Party, and because Catholics were more likely than others to oppose abortion, Republicans at this time were more pro-abortion than Democrats. Although we often forget this fact, it's interesting to recall that in early 1972, 59% of Democrats and 68% of Republicans thought that the decision to have an abortion should be made solely by a woman and her physician. Indeed, Republican politicians spearheaded some of the earliest efforts to liberalize abortion laws. Barry Goldwater, for example, supported abortion rights. And in 1967, California Governor Ronald Reagan signed a bill that liberalized that state's abortion laws. But because of other, more liberal elements in the Democratic Party itself as an institution was officially more pro-abortion than Republicans. Seeing an opportunity to draw disaffected Catholic voters away from the Democratic Party, Republican leaders began to move towards a more anti-abortion stance. They knew that if they could succeed in this effort, they could bring about a profound shift in American politics. This strategy was clearly evident in President Richard Nixon's policies during the 1972 election. With a clear sense of the political ramifications of the abortion issue, Nixon embraced an anti-abortion stance in a strategic effort to draw Catholics into the Republican camp. Nixon knew what he was doing. In the 1972 election, large numbers of Catholics who were prepared to cast single-issue votes on the issue of abortion voted Republican for the first time in their lives, helping Nixon to win an overwhelming victory in that year's presidential election. At roughly the same time, though, the rising voice of the women's movement began to shape public discourse on abortion. In February of 1969, for example, Betty Friedan, the founding president of the National Organization for Women, delivered a rousing address in Chicago at what was billed as the first national conference on abortion laws. Friedan declared that there is no freedom, no equality possible for women unless we assert and demand control over our own bodies, over our own reproductive process. At the end of the conference, the participants founded the National Association for Repeal of Abortion Laws, NARAL, on the premise that what was needed was a complete overhaul of America's abortion laws. Later that year, Planned Parenthood and the American Public Health Association also called for repeal of America's abortion laws and declared abortion to be a fundamental personal right of the woman. As these organizations moved to the forefront of national debate, and as women began courageously for the first time to share their experiences with illegal abortions, the law began to change. In 1970, 4 states, Hawaii, Alaska, Washington, and New York, legalized abortion in the first trimester, thus restoring the law to more or less what it had been at the time that our Constitution had been enacted. Opponents of these laws quickly mobilized their forces, however, and adding fuel to the fire, in early 1972, Congress approved the Equal Rights Amendment and submitted it to the states for ratification. This immediately led religious and conservative activists to tie the issue of abortion to even larger conflicts about the appropriate role of women in American society, to the sexual revolution, and to the meaning of so-called family values. Suddenly, the legislative progress on abortion that had begun only a few years earlier ground to a halt. Despite the growing and clear majority support for legalizing abortion, no state legislature now acted on that view. Single-issue voters effectively blocked the willingness of legislators to take that position. Indeed, in New York State, which had legalized abortion in the first trimester only a year before, once the pushback occurred, the state legislature voted to repeal the repeal and to reenact the traditional law that banned abortion absolutely. Republican Governor Nelson Rockefeller vetoed that legislation, declaring that the vast majority of citizens of New York support legalizing abortion. The pushback against that is clearly dominated by religious factors, and in our democracy, which is committed to the separation of church and state, those religious views cannot be permitted to dictate the law for other persons. Now, faced with this sudden paralysis in the legislative arena, pro-choice advocates began for the first time to think about challenging the constitutionality of anti-abortion laws in the courts. Now, initially, this seemed a long shot, because in the words of New York Times columnist Linda Greenhouse, the idea of a constitutional right of abortion seemed somewhat illusory. But with legislative change effectively blocked, the courts now seemed the only plausible alternative. In 1970, after the Connecticut legislature repeatedly refused to amend its 19th century anti-abortion law, a group of women activists formed a new organization, Women versus Connecticut, to challenge the constitutionality of the law. We want control over our own bodies, they declared. We are tired of being pressured to have children or not to have children. It is our decision. 6 weeks after they filed a lawsuit challenging the constitutionality of the Connecticut statute, Judge Edward Lombard, a conservative Eisenhower appointee, held that in this Connecticut law, quote, Connecticut trespasses unjustifiably on the personal privacy and liberty of its female citizens in violation of the American Constitution, and that the state's purported interests in banning abortion are, quote, insufficient to take from the woman the decision that she, as the appropriate decision maker, must be free to choose. Cases challenging anti-abortion laws now started popping up everywhere. In Georgia, a group of plaintiffs, including doctors, nurses, and members of the clergy, challenged the constitutionality of Georgia's anti-abortion statute. The federal court in Georgia also held the statute unconstitutional, explaining that the constitutional concept of personal liberty embodies a right of privacy that is broad enough to include the decision of a woman to terminate an unwanted pregnancy. At roughly the same time, in Texas, Linda Coffey and Sarah Whittington, recent graduates of the University of Texas Law School, teamed up with a plaintiff identified only as Jane Roe to challenge the Texas anti-abortion statute. On June 17, 1970, the federal court in Texas held that the Texas law violated the fundamental right of women to decide for themselves whether or not to have a child. A year later, the Supreme Court of the United States announced that it would hear the case of Roe versus Wade. Now, many Americans today think of Roe versus Wade as a radical left-wing decision, but that was not at all the view at the time. By 1973, a substantial majority of Americans supported the right of a woman to terminate an unwanted pregnancy. And Gallup polls at the time showed that 2 out of 3 Americans thought abortion should be a matter for decision solely between a woman and her physician. Moreover, as we've seen, the lower courts were already moving sharply in that direction, in a direction that anticipated Roe v. Wade. And in an overwhelming 7-2 decision, the Supreme Court held that those lower courts were correct, and that the Constitution does indeed guarantee a woman's right to decide for herself whether or not to bear a child. Strikingly, 3 of the 4 justices appointed to the Supreme Court by Richard Nixon, who had dedicated himself to appointing conservative justices, joined the decision. Indeed, without their support, Roe would have come out the other way. That Warren Burger, Harry Blackmun, and Lewis Powell joined Justices Douglas, Brennan, Stewart, and Marshall in Roe speaks volumes about the mainstream nature of the decision at the time. The plain and simple fact is that at the time Roe v. Wade was decided, the justices did not view the abortion issue as posing a particularly divisive ideological question. Although the justices certainly understood the stakes, none of them imagined that Roe would later come to be a central flashpoint of American politics. This understanding of Roe is consistent with both the news coverage and the public reaction at the time. Because Lyndon Johnson died on the same day that the court announced its decision in Roe, newspapers, magazines, and news shows treated Roe as only a secondary headline. U.S. News & World Report, for example, did not even mention Roe on the front page of that week's issue. As the editors observed 40 years later, the far-reaching effects of the decision simply weren't evident at the time. This view is also consistent with the editorials and commentary about Roe, which were overwhelmingly approving. Even newspapers in traditionally conservative states took this view. The Atlanta Constitution, for example, characterized the decision as, quote, realistic and appropriate. The Houston Chronicle called it sound, and the San Antonio Light gushed that although the ruling was not perfect, it was as close to it as humanly possible. Moreover, the American people clearly endorsed the decision in Roe. In polls taken at the time, only 40% of Americans questioned the court's decision. To put that in perspective, it's useful to compare the public's reaction to Roe with its reaction to other, more controversial decisions. In 1962, for example, the Supreme Court held that prayer in public schools was unconstitutional. 79% of Americans disapproved of that decision. In 1967, after the court held laws prohibiting interracial marriage unconstitutional, 72% of Americans disapproved. In 2010, after the court held laws limiting corporate campaign expenditures unconstitutional, 80% of Americans disapproved. But only 40% of Americans disagreed with Roe v. Wade. An additional measure of how uncontroversial Roe was at the time is the fact that when President Gerald Ford nominated John Paul Stevens to succeed Justice William Douglas in 1975, 2 years after Roe, not a single senator asked Stevens a question about Roe or about his views on abortion. Even most evangelicals at the time did not challenge the decision. For in 1973, most evangelicals still regarded abortion as a Catholic issue. The one group that did strongly condemn Roe from the very moment of the decision were Catholics, who disapproved of the decision by a margin of 56 to 40%. Even that is not overwhelming. Indeed, within days of the decision, thousands of telegrams and letters of protests from Catholics began pouring into the Supreme Court. Many of them form letters from Catholic school students denouncing the justices as murderers and butchers. The vast majority of these letters were addressed either to Justice Blackmun, the author of the Supreme Court's opinion in Roe, or to Justice Brennan, the court's only Catholic justice, for whom, by the way, I was serving as a law clerk at the time. And I'll tell you one interesting and amusing anecdote about this. The justices themselves, for the most part, were not interested in reading these thousands of letters. But they posed an administrative problem for the court because the Supreme Court was not used to getting thousands upon thousands of letters. And so boxes and boxes piled up in the hallways. And the question was what to do with them. And nobody actually wanted to read them except some law clerks. And at 2 in the morning, one would see law clerks sitting on the floor in the halls of the Supreme Court, going through these boxes, swearing, and looking through the envelopes. And the reason they were doing this was because a number of them had gone off to interview with law firms for possible jobs for the following year, and they were waiting for the reimbursement checks. And so they were plowing through all of these letters, looking to see if they could find their checks. Now, of course, as we know, Roe eventually emerged into a bitterly divisive issue. But this did not happen until the end of that decade, as the culture wars exploded over such issues as the Equal Rights Amendment, the beginning of gay rights, obscenity questions, women's liberation, thus inflaming the evangelical community. By this time, polls showed that more than a third of all Americans identified themselves as born again, and evangelicals had become the nation's largest religious denomination. When the Reverend Jerry Falwell founded the Moral Majority in 1979, he brought together for the first time the many disparate elements of Christian fundamentalism into a single unified political movement. Falwell explained that if evangelicals worked together, they had the power, quote, to take control of the national government. The Moral Majority raised huge amounts of money to support political candidates, and in state after state, its members wrested control of the state Republican apparatus from party regulars. By the summer of 1980, Republican leaders were treating Falwell more than any other religious figure in American history, like the leader of a powerful political constituency. The Christian broadcaster Pat Robertson boasted that the evangelical community now had, quote, enough votes to run the country. And in his pursuit of the presidency, Ronald Reagan now called for a constitutional amendment to overturn Roe versus Wade and promised to appoint pro-life judges at all levels of the judiciary who would pursue that path, thus ushering in a historic era of judicial nominations shaped in no small part by religious conceptions of constitutional law. With Reagan's election, James Dobson, the founder of Focus on the Family, proclaimed that the evangelicals had finally come home, and that home was the White House. In the years since 1980, a succession of Republican presidents have sought to appoint Supreme Court justices who would overturn Roe v. Wade. Interestingly, though, 3 of those now 8 justices, Sandra Day O'Connor, Anthony Kennedy, and David Souter, disappointed those who appointed them, demonstrating a respect for precedent, an understanding of the plight of women in a world in which abortion is illegal, and an appreciation of the fundamental nature of the right at issue in Roe. O'Connor, Kennedy, and Souter consistently reaffirmed Roe v. Wade despite repeated efforts to overturn the decision. Having learned that lesson, though, Republican presidents have grown ever more determined not to replicate those mistakes. And with the appointments of justices like Antonin Scalia, Clarence Thomas, John Roberts, Samuel Alito, the court has come several times within a hair's breadth of eviscerating Roe v. Wade. So where are we today? Well, had President Obama's nominee, Chief Judge Merrick Garland, been confirmed by the Senate, as he should have been, that would pretty much have locked Roe into place for the foreseeable future, for there would then have been 6 justices on the Supreme Court who support a woman's right to decide for herself whether or not to bear a child. Largely to prevent that outcome, however, Senate Republicans, in an unconscionable and unprecedented abuse of authority, refused even to consider Merrick Garland's nomination in the hope that an anti-abortion Republican would win the White House in 2016. The confirmation of Justice Neil Gorsuch puts the court back where it was before Justice Scalia's death. That is, the court will once again be divided 5-4 in favor of upholding Roe v. Wade. But if one of the 3 oldest justices on the court, Ruth Bader Ginsburg, Anthony Kennedy, or Stephen Breyer, should leave the court for reasons of health or otherwise in the next few years, and if Donald Trump gets to appoint another committed conservative to the court, there will then be 5 justices who will likely vote to overrule Roe v. Wade. In the United States today, 30% of all women have at least one abortion during their lives, and approximately 1 million legal abortions are performed in the United States annually. If Roe is overruled, some states will no doubt legalize abortion. but most will not. Think of the Electoral College. If this comes to pass, hundreds of thousands of women, mostly poor and minority, will once again be thrown each year into the dark and dangerous world of back alley abortions. So what then is the takeaway of this talk? Well, other than hoping to incite your curiosity so you buy my book, it's to make clear that a world where abortion is illegal is not the state of nature. From the ancient world until the late 19th century, abortion was readily, safely, and legally apportioned to women. Roe did not mark a radical departure from history, but a return to the world of the framers, the one that they knew and they assumed would continue. It was only the illegitimate infusion of religious dogma into our secular law that changed all this. And especially in a nation dedicated, or supposedly dedicated, to the separation of church and state, this is truly a tragedy waiting once again to happen. Thank you.
Folks, if anyone has any questions, we invite you to raise your hands, and we both have mics if you give us a chance to get to you.
Right. So if you didn't hear that, if you have questions, raise your hand, and there are people with mics who will come running to you. I'm not supposed to call on people. The microphone people do.
Thank you. That was really an excellent talk. I'm greedy, so I'm going to try to throw in two questions. One is, with the takeaway at the end, it seems to me that the context of the world that the framers lived in is part of the justification for your statement, yet there were plenty of things that we would all agree we'll say, inconsistent with the world that the framers lived in, that we've sort of tried to move on, human rights and that kind of thing. So I'd like you to comment on that. And the other is there evidence that Gorsuch himself would overturn if he had the opportunity?
So the first question is a question really about constitutional interpretation. And what is the relevance of the fact that the framers lived in a world in which abortion was commonplace, legal, and assumed indefinitely to be legal because it always had been. So an originalist, a narrow-minded originalist might say that we do not know that the framers affirmatively intended to create a constitutional right of abortion. It certainly says it nowhere in the Constitution, and therefore it's not our business to create a right out of whole cloth. And that ends the inquiry, right? But it's actually more complicated than that, because the framers were very uneasy about adopting a Bill of Rights. And one of the reasons they were uneasy about it was because of the concern that if you list a series of constitutional rights, it creates the implication that those are the only rights that the people have. And this was something that they were very concerned about, because they were men of the Enlightenment, and they believed that knowledge grows from time to time, that they would not anticipate all of the issues that might arise in the future, and they therefore were concerned about listing rights, giving rise to this implication. So they adopted, precisely for this reason, the Ninth Amendment, which expressly provides that the enumeration of specific rights in the Constitution shall not be taken to abridge or deny other rights retained by the people. It was an explicit invitation to say there are other rights. And therefore the inquiry into whether there are fundamental rights that should be recognized in the Constitution, whether the right to marry, whether the right to use contraception, whether the right to have children or not to have children is a fundamental right, is not precluded by the absence of those rights being spelled out in the Constitution because of the existence of the Ninth Amendment. The fact, however, that the framers did take for granted that there was a freedom of individuals to have abortion certainly lends credibility to the argument that that should be understood to be a right, relative to if they had outlawed abortion at that time, it would have been a harder argument to make. So it seems to me it's relevant on the question, although it's not necessarily dispositive one way or the other. On the question of Gorsuch, I would say, based on everything I know about Justice Gorsuch, from people who know him, from reading his opinions, from people who know his background, that he is very much a justice in the mold of a Justice Alito or Scalia or Thomas or Roberts, and that he will be on these kinds of so-called moral issues aggressively conservative. And he might surprise me, but I don't think so.
Okay, do we still have a question over here? Okay, over here.
This is one of
Yeah.
them.
Oh,
No, you go.
thank you for your wonderful talk and for using history to instruct. In the closing part of your remarks, you put a fair amount of emphasis on religious dogma as causing the situation we're in today. But you also, in your talk, highlighted the Republican Party's use of the abortion issue to really politicize it into where we are now, where Supreme Court justices are evaluated almost centrally on that criterion. So I wondered if you could comment a little bit on the way that abortion has, and also women's ability to choose in general, has become sort of, the political goal, and abortion is just the means to the end, in the sense that there's a struggle going on for how much freedom women should have.
Well, I mean, I think it's fair to say that mainstream Republicans, and there are fewer and fewer of them today, in terms of, that's not meant to be a criticism of them. It's a product of the way in which we select our politicians now. Things have become so polarized. But mainstream Republicans in the past and mainstream Republicans today, my guess is they don't personally tend to have a strong view about abortion, and may even, like someone like Reagan or Nixon, actually not be opposed to abortion themselves. They use this as a way of gaining political power, as politicians do. But it is also the case that a substantial portion of Republican voters do feel strongly about abortion. And whether this will carry over to other issues about the status of women in society, I don't think quite as dramatically as it will. It has implications for other issues about gays and lesbians, for example, and transgender persons. And the failure of the Equal Rights Amendment is another good example. When the Equal Rights Amendment was proposed, it was approved by substantial majorities at both the House and Senate, including Republicans as well as Democrats. But then when the pushback came on family values and the culture wars and so on, Republican politicians in states across the country started opposing the ERA because it became politically expedient to do so. But these were basically the same Republicans as those in the House and Senate who had voted for the ERA when, at that moment, there hadn't yet been the pushback. So I think, who are Republicans have changed over time, no question about that, because of the constituents and their voters. But I do think that the so-called mainstream Republicans are still very much like people like Ronald Reagan and Barry Goldwater and Richard Nixon, that on these issues they were not deeply religious and not deeply affected by religious attitudes themselves. They're basically pretty non-religious individuals, and their views on these issues, my guess, were far more moderate than the ones they had to take from a political standpoint.
Next question in the back.
Hi, this is a two-part question on the Equal Rights Amendment. So Nevada just passed or ratified last month. So I want to, but I know there's a deadline and all of that. So can you speak to whether 2 more states ratify? Do you think the Equal Rights Amendment would become a constitutional amendment? That's part one. And part two, if it is, or if it does become a constitutional amendment, does it grant women a right to abortion?
So I was under the impression, if I may be wrong, that the time for ratifying the Equal Rights Amendment expired. And therefore, there is no Equal Rights Amendment that is now pending before the states as a matter of a federal constitutional amendment. But even if it were to be ratified today, it would not change the law dramatically, because in the years since then, the court has interpreted the Equal Protection Clause in a way that has become much more negative about laws that discriminate against women. And I would say 90% of what would have been accomplished by the ratification of the Equal Rights Amendment has already been achieved by the court's interpretation of the Equal Protection Clause as granting women a high degree of protection against discrimination. On the other hand, I don't believe either the court's interpretation of the Equal Protection Clause or the Equal Rights Amendment would have been taken to require the decision in Roe v. Wade. Although the argument that laws against abortion discriminate against women derives largely from the accurate cliche that if men got pregnant, abortion would be legal. The fact is that given the technical notion of how equality jurisprudence exists, a law that does not treat men and women differently when they are similarly situated does not necessarily or almost never would violate either the Equal Protection Clause or the Equal Rights Amendment. And since men can't get pregnant, laws prohibiting abortion don't technically discriminate against men. It says anybody who gets pregnant can't have an abortion, period. That it just happens to be only women doesn't produce an equal protection question. Now, so that's the reason why the court was unwilling to rely upon equal protection in Roe v. Wade. And my guess is the current court certainly wouldn't change that if the Equal Rights Amendment were adopted.
Okay, we have a question over here.
Is really the controversy over abortion really a debate over modernity rather than morality, but it's couched in the terms of morality?
Say a word more about what you mean by modernity.
It's a debate over abortion today, more a debate over modernity.
No, but what do you mean by modernity in that?
I mean, like, for example, equal rights, marriage rights, birth control, but those on the right are really saying, well, we don't accept what's happening in the modern era, but they can't come out and say it, so they're couching it in terms of morality.
So, in some sense, as you described it, there is a pushback against changes that have taken place in society that you describe as modernity, that people want to go back to a better era, right? They want to go back to the 1950s, when women knew their place, and when men were dominant across all sorts of areas of life. So there are certainly people who want to do that, and the issue about abortion is just one tiny piece of that larger issue. So I don't doubt that there are people who support getting rid of Roe v. Wade and support getting rid of equality under the Constitution for women because of those reasons, which are not based in religion itself. So I think that's a fair point. But I think the driving political force about abortion, in particular, is clearly driven by religious groups. And that seems pretty clear when you look at poll numbers, that those people who are opposed to abortion correlate very highly with those who attend church on a weekly basis. And that also overlaps with modernity, of course, and counter-modernity. But I think religion is the single most important driving force in the anti-abortion movement.
Okay, I have a question over here.
Hi, thank you for your really informative talk. And I also mirror the appreciation for the rooting the context of history within your talk. That sort of builds on what people have said here before. We started in the introduction to you with your quote related to the First Amendment rights for the neo-Nazis to march in Skokie and rooted that in the First Amendment. And it seems like today this idea of free speech, irrespective of the political ramifications, like safe spaces on college campuses and such, have created a robust dialogue grounded in interpretations of the First Amendment. So my question in terms of the abortion issue, and maybe this is naive, is how can we, in a sense, move beyond the political piece of it being rooted in religious belief systems when the Constitution obviously is supposed to keep a separation between church and state. So how do we, I get the political aspect, but how do we get a dialogue going that is rooted in interpretations of the Constitution, the ways that the First Amendment has now been, I think, in really important ways, readdressed and not interpreted, but discussed in the public discourse? Sorry,
The question is, we're now seeing lively debates about free speech, particularly on college campuses, about what are the bounds of free speech and so on, and how would we generate similar debates about the meaning of the Constitution with respect to the issue of abortion. And that's the first thing I'd say is there aren't really serious debates about the meaning of the First Amendment at a large level. There are disputes about what institutions should be dealing with here, but I don't think they're taken very seriously by lawyers or judges, to be honest. I think they have a pretty good sense of what the boundaries are here on the First Amendment issues. But nonetheless, I understand what you mean. They become a clash about these issues. People are talking about them, trying to figure out what the boundaries are. I think here what's necessary is a pushback against the very plausible direction that Roe would be overruled with the next justice appointed at the Supreme Court. And I think that requires, one of the reasons why I highlight the world of illegal abortion is most people have forgotten that. Most people don't really know what that means. And how ugly and how awful and how horrifying it was for people. And I think part of what people need to do is to bring that back to the fore. And it's hard to do because women who had illegal abortions are now getting on in years. But that doesn't mean they cannot be powerful and important advocates. But I think those people who are inclined to be in favor of the right to abortion, and those people who don't feel strongly one way or the other about it, need to hear much more directly what it would mean to go back to that world, and what it would mean in the lives of these women. And just as that was largely unknown until the late 1960s, other than the people who experienced this, or the people right around the people who experienced this, I think it's been forgotten now. I think people think about a right to abortion, not a right to abortion. They tend to think either you have a right to abortion and you have one, or you don't have a right to abortion and you don't have one. But of course, that's not what happens, right? What happens is you do have one, and you have one in terrible and dangerous circumstances. And I think that needs to be brought much more openly, and people need to talk about their experiences. And that's what influenced the justices. And as I mentioned, I was a law clerk for Justice Brennan the year of Roe v. Wade. And one of the things that the justices talked about was their awakening, only in the couple of years right before that, to what the dark world of illegal abortion really was. I assume all of them, or almost all of them, would have said, I never knew anyone who had an abortion. I never talked to anyone who ever had an abortion, even though they might have known people but didn't know it, of course. And having heard what this is like, that clearly affected their judgment there. And I don't know whether that would persuade the kinds of justices who are now on the Supreme Court, who would be opposed to Roe v. Wade, but I think that can help to persuade people in the political arena about this, and can help to persuade people, if Roe is overruled, that why their state should legalize abortion, or why states, for example, that allow abortion should take affirmative steps to help particularly poor women in other states where abortion is illegal to be able to come to their state and have legal abortions. So I think there are ways in which this needs to be understood, not just as sort of an abstract right, but as an on-the-ground reality about what this means for the women who actually are pushed into that circumstance of going back to knitting needles and blindfolds. That's not a world we want to go to.
We'll take our last question in the back. Before we do, I have a couple housekeeping notes. One, I want to remind you that we have unabridged bookstores behind us. Book signing will take place on the second floor. If you're a member, we invite you to join us also on the second floor for the Members Lounge, or perhaps if you're not, consider joining. Lastly, I do have a program immediately after this, so I will kindly ask you to swiftly exit, and I hope you will join us again.
Thank you, Professor. My question has to do with personhood amendments. And with the emergence of these attempts with personhood amendments and the historic opposition to contraception by anti-choice groups, isn't the real goal to stop women from having non-procreative sex? And if so, why isn't that sort of the debate that we're having?
Well, that was certainly the goal in the late 19th century, as I noted, that the goal was to prevent women from having, as you described, non-procreative sex, except in marriage. I don't think that is the dominant goal today. I think that society has changed, social values have changed. I think even those in the evangelical movement don't see that as one of their primary aims. The personhood amendment issue, though, is an interesting question, because when I describe what would happen in the Supreme Court, or what might happen in the Supreme Court with one or more conservative justices replacing the more liberal justices with respect to abortion, is that the court might overrule Roe. That would still allow the states to make abortion legal in their own states. A much worse scenario, which I think is not likely, but is not impossible, is that the justices of the Supreme Court would go a large step further and hold, as has been argued at various times, that the fetus is a person within the meaning of the Constitution. And just as if a state adopted a law that said parents are allowed to kill their children up to the age of 2 if they decided they didn't really want them after all, that law would violate the constitutional rights of the children who were being murdered because they are persons under the Constitution, and a state cannot authorize their murder. It is not inconceivable that this group of justices would find that a fetus is a person under the Constitution, and that for a state to allow abortion would itself be unconstitutional. And even those states that would want to legalize abortion would then not be permitted to do so. Now, I don't predict that will happen, but it's not completely off the table. And I don't know that a justice like Scalia, for example, might not have gone that far, or Thomas might not have gone that far. Their own views about abortion are so deeply rooted and so intense that it's not inconceivable to me that there could be a set of justices who would go that far and basically make abortion unconstitutional. A lot turns on the Supreme Court. Who we are as a society is in fact affected in important ways by who the justices of the Supreme Court are, what values and beliefs they take to the Constitution, the methodologies they adopt in interpreting the Constitution. And that's why what happened to Merrick Garland happened. And as I said earlier, I regard that as one of the truly unconscionable and illegitimate actions in the history of judicial nominations and confirmations in our nation. And the sad thing, the really tragic thing, is that neither the media nor the Democrats made it the kind of issue they should have made it. And of course, the conclusion of that is when Judge Gorsuch is nominated, the Republicans get rid of the filibuster, which had been in place for 150 years for Supreme Court nominees, so that they could get Gorsuch confirmed, even though he could not have been confirmed over a filibuster. So the manipulation of the judicial confirmation and nomination process that we're now seeing is truly dangerous and corrupting of some of the core democratic procedures and principles that we've had in the past. So these are issues about which you should all be very concerned. Thank you very much.